Hey, hello, everybody. I'm David Goldstein, the chair of the nonprofit practice group at the Sir Tillman Bowling Law Firm. And I'm going to introduce you to my partner, Doug Rowe, who is going to introduce himself, and then he's going to start today's presentation.
Sure. Thank you, David. Doug Rowe, I'm an employment lawyer. I represent for-profit companies and not-for-profit companies. Just generally speaking, harassment, wrongful termination, retaliation, discrimination, and wage and hour disputes are among the top employment claims against nonprofit employers. I'm going to start today, though, with complying with the wage and hour laws in New York. Generally speaking, employers have to pay their non-exempt employees time and a half for all work over 40 hours. They have to comply with the minimum wage laws, which are different throughout New York State, and they have been different throughout New York City through the years also. There are some unique laws in New York also that nonprofits need to be aware of. There's something called the spread of hours pay, which requires employers to pay their employees an extra hour at the minimum wage for every day their hours exceed 10. So that's sort of a nuance in the law that most employers aren't aware of until they get caught through a Department of Labor audit or a federal lawsuit. So it's something to be aware of. And when I talk about wage and hour laws, really it's important to be in compliance. So the first step is to be aware of these laws, and once you're aware of these laws, then you figure out how to get into compliance and stay in compliance. Most employers in New York State are aware of the requirement to provide a notice of pay rates for new hires. That's important, and it's important that that be completed in its entirety. It's a form called Wage Notice 95-1 Wage Notice. The left side has the employer information. The middle has the pay rates and pay days. The right side, it has to be signed by the employer and the employee, and a copy has to be given to the employee. The reason why I stress the technicalities of this form is that this form arises from a statute, and the statute sets forth this requirement. And we've been involved in litigation matters where, by way of example, first of all, it's a $5,000 penalty if you don't provide the wage notice form to employees. And you know, if you have a practice of not providing the wage notice form to employees on a regular basis, needless to say, that could be multiplied and add up very quickly. But as I said before, the information has to be completed. We had a case several years ago where the employer had 600 wage notice forms. Each one had a typo in it. It said West 25th Street instead of West 26th Street. And the plaintiff's attorney in that case took the position that everyone was wrong as a matter of law because he didn't have the employer's address on it. We went to mediation on it. That was a $3 million issue. We ended up settling the case for other claims in the case, but just to be aware of what I mean by compliance, it's that important, you know, to be aware of all these technicalities in the law. Wage statements is basically a pay stub, but the pay stub has to be completed. The wage statement also arises from a statute, and it requires all the general information about the employee's work week and the hours worked, et cetera. So that must be complied with as well. And that's also a $5,000 penalty for not providing wage statements on a regular basis. I'm going to just touch upon frequency of pay. It doesn't apply in the nonprofit world, but there's a law in New York that requires employers to pay their employees, pay manual workers weekly. And there was a case several years ago that basically held that if manual workers are paid bi-weekly instead of weekly, that the employer owes the full amount of the late payment is liquidated damages. Because every other check is late, the damages are basically half the employee's salary for the entire year. Again, it doesn't apply in the nonprofit world, but it's just something to be aware of. When I talk about compliance with the wage and hour laws, it's so important to keep records, time records and payroll records. So employees know what they're being paid for, know what their hours are. And that's the way best to stay in compliance and avoid any issues. And when I say that, I can't tell you how many times I've been involved in cases where the employer didn't keep proper records. Where the employer doesn't keep proper records, whatever the employee says were the hours is going to govern the case. And needless to say, employers don't want to find themselves in that position. So again, it's urgent that the employer keep track of the employee's hours. I mentioned beware of rounding. There's basically an unwritten law in New York State that if an employee punches in 7 minutes before their start time, you can round it to the start time. If they punch in 8 minutes or more before their start time, you have to round it back to the closest 15 minutes. Same with the end of the shift, but it's important to be aware of that issue. Basically, if employers are using that process, the better advice would be not to engage in have a rounding policy and just pay the employees for all hours that is shown on their time records. But it's just an issue. I wanted the employers to be aware of this issue. Overtime pay under the Federal Fair Labor Standards Act basically does not apply to nonprofits unless the nonprofits have $500,000 in annual revenues, and those revenues have to be in ordinary commercial activities, such as operating, having a business purpose, like a gift shop. And that 500,000 in annual revenues does not include contributions, membership fees, and donations. So that's the general overview of the wage and hour laws. New York regulations. There's a minimum wage order that applies to nonprofits. There are exemptions for nonprofits. So needless to say, volunteers are not included in the wage orders. Students are not included in the wage orders. But, one of the things to be aware of when you talk about volunteers, volunteers may not replace paid staff to do work of paid staff. So you can't call somebody a volunteer, have them actually volunteer their services, but have them perform work as if they're an employee. We had a case several years ago where we represented a nonprofit, and one of the volunteers offered to start driving for the company and driving and picking up some, I think veterans, it had to do with a veterans organization. And he provided these driving services on a regular basis. And at some point, he considered himself an employee. He filed a claim with the New York State Department of Labor, and the Department of Labor concluded that even though he was called a volunteer, he was actually an employee entitled to be paid for his services. So again, something to be aware of when you talk about volunteers. Just make sure that if they look like if they look like an employee and smell like an employee, they're an employee. So just consider that when you how you treat volunteers. One of the big issues in wage and hour litigation is exemptions. A lot of employers believe that merely because they pay an employee on a salary basis, they must be exempt, but that's not the law. There are certain exemptions that exist in the law. There's the executive exemption, where the primary duty is managing the enterprise, and the employee has to supervise at least 2 full-time employees and have the right to hire and fire. There's the administrative exemption, which is really a little more nebulous. I would call the administrative exemption. It could be an HR director, for example. It could be a somebody like that, but it's really not clear as to what an who falls within the administrative exemption. So be careful of that exemption. Then there's a professional exemption, doctors and lawyers and creative professionals in artistic and creative endeavors. There's the outside sales exemption, where the primary duty is making sales away from the employer's place of business. And then there's a computer-related occupations exemption as well. When it comes to having employees remain exempt, they also have to be paid, even if they satisfy the duties test. They also have to satisfy a salary threshold test. So the salary threshold is in New York City and Nassau, Suffolk, and Westchester, it's $11.25 a week. The remainder of New York State is $1,064.25 a week. And these are the state thresholds. There's also a federal threshold that's only $684 per week. But again, if you want to have a manager who you want to treat as exempt, that manager has to be paid at least $11.25 a week. Otherwise, you're destroying the exemption, and that manager would be entitled to overtime. Best advice is really to conduct a self-audit to determine whether the nonprofit is in compliance. It's important, as I said before, to review the exemptions. And again, the potential claims that exists for not complying with the wage and hour laws are, you could be subject to a New York State Department of Labor audit, a US Department of Labor audit, a private lawsuit that may be brought in state court or federal court, and they could also be brought as a class or collective action under state and federal law. So, and the potential damages there are not only for the unpaid wages, but also liquidated damages, which is the full amount of the unpaid wages on top of the unpaid wages, and then attorney's fees. I want to touch upon independent contractors. I've seen that a lot of nonprofits will consider treating, classifying somebody as an independent contractor, and that's not necessarily a proper classification. First of all, there's a IRS 20 factors test. New York State has a similar right to control test. But as I said before regarding volunteers, if the person looks like an employee and smells like an employee, you should really consider them an employee, not an independent contractor. The potential risk in misclassifying someone as an independent contractor rather than employee is significant. First of all, you have the potential, you have the payroll tax issue. You have the potential, first of all, the discrimination laws don't protect independent contractors. They do protect employees. You have the wage and hour issues, which we've already discussed. So, and by the way, I just want employers to be aware that merely because you classify somebody as an independent contractor, and even if the independent contractor agrees that I am an independent contractor, and even if they sign an agreement that says, this is my independent contractor agreement, that doesn't mean they're an independent contractor. So there's really no way to properly protect a nonprofit if it comes down to whether they've properly been classified as an independent contractor or not.
And Doug, I just want to interject here that I've seen that fact pattern that you mentioned countless times, where an agreement is in big, bold, capital letters at the top, independent contractor agreement. And throughout the agreement, 120 times, the words independent contractor are used. And that has no bearing on whether the person is an independent contractor or not. So if you're in doubt, get legal advice and make sure that you're classifying employees or independent contractors properly.
Right. Thanks, David. And as a matter of fact, with regard to independent contractors, the rules appear to be tightening that much more. The Department of Labor has proposed independent contractor rules, which really is going to make it more difficult for an employer to be able to sustain a classification of a person as an independent contractor. So it's something to be aware of. If employers have gotten away with it for years, it's tightening up that much more. I touched upon volunteers before as well. I'm going to mention working from home. It seems that, since COVID, working from home is an issue and it remains an issue. And I think it will continue to be an issue for years to come. So it's important to remember that where you have an employee work from home, the same rules that exist in the workplace also exist when the employee works from home. So, it's, as I said before, it's important to keep track of the records, keep track of the employee's time. So figure out how best to track their time when they work from home. You don't want to have a situation where you have an employee who is working morning, noon, and night and 2 a.m. and, how are you going to really determine, how many hours that person worked? So you really need to, set a schedule, establish boundaries. And by the way, remember that all the New York State labor laws apply. So you have to remember meal periods, for example. Employers in New York State are required to provide their employees with a half-hour unpaid meal period every day in New York every day. But it's something to remember that the New York State laws apply even when the employee works from home. Pay attention to expenses. If you have if you have a minimum wage employee who's working from home, and that minimum wage employee is required to incur expenses for computer paper, printer cartridge, things like that, and you don't reimburse them for that, there's an argument that there's a minimum wage violation because they're incurring expenses. So during weeks that they're incurring those type of expenses and they're not getting reimbursed for it, there's a potential minimum wage violation. It's just something to be aware of. The posters that exist that are required to be posted in the workplace also apply to working from home. And in fact, New York State just enacted a new law effective this year, permitting electronic or requiring electronic notices for the posters as well. And there should also be a work from home policy, and train supervisors to be vigilant in how they handle employees who do work from home. With respect to employers that may advertise for new positions, there's a new law in New York. It's been in effect in New York City since November of 22. In New York State, a new bill was signed and effective September 17th, 2023. That will be the law in the state, and that it's the salary transparency law, and it requires that anybody who advertises for a position indicate the compensation or range of compensation and the job descriptions for that position. And there are fines and penalties for non-compliance. So that's some background. And again, I touched upon, the general laws to be for employers to be aware of, but new employment laws for 2023. New York Labor Law 201. I mentioned the notices must be posted, and this is where employees can be made aware of the postings electronically. Warehouse worker, I don't know if any of the nonprofits have warehouse employees, but if there are warehouse employees who are subject to quotas, then this law applies to the employers as well. And these are all the new laws in 2023. Minimum wage increase in upstate New York. It is increased to $14.20 an hour. That's in 2023. Expanded protection for pregnant and breastfeeding workers. That is something that employers need to be aware of. Employers, this a law called the Pump Act. It's federal law. Requires reasonable break time to express milk for 2 years following the birth of a child, and employers are required to provide employees a place to express milk in the workplace. COVID-19 vaccination leave still exists through the end of this year. Employees are entitled to up to 4 hours of leave for vaccination. I'll touch upon non-competes. The FTC has a proposed rule banning non-competes under federal law. It's subject to rulemaking right now. Whether it's going to be passed or not is a different issue, but that we're all monitoring that issue. New York State also has a pending rule, possibly also banning the use of non-competes in New York State. New York City has come out with a new law. It's the first in the nation, landmark piece of legislation requiring bias audits if employers are using, AI technology for hiring. So that's something to be aware of also, because what the government has found is that employers can inadvertently discriminate against employees by use of AI technology, which could be discriminatory, in its existence. If you're going to monitor employees, you have to give written notice of electronic monitoring. There's an updated EEOC poster. Make sure you're using that, replacing the one you have with the updated EEOC poster. I mentioned artificial intelligence tools. The EEOC is all over this issue as well. And New York City just recently enacted height and weight anti-discrimination ordinance. Another thing for employers to be aware of. So don't discriminate against employees based on height and weight. That's it. David, thank you. Doug Rowe, if anybody has any questions, feel free.
I had some requests from people who were attending today to spend my time today talking about common missteps that we see in the governance realm. When clients come into us and ask to help with a governance reset, or when there's been a problem and clients come in and ask us to help them fix it, what are the missteps that we see happening over and over again? And so that's what I'm going to spend my time talking about. I'm going to start with the fundamentals, and part of this is why is it so important to avoid these missteps, and that's because directors and officers of nonprofits have fiduciary duties. Those are legal duties, and if you breach those duties, there can be personal liability. There's 3 fundamental legal duties: the duty of care, the duty of loyalty, and the duty of obedience. And the duty of care is that a director must discharge the duties of his or her position in good faith and with the care that an ordinarily prudent person in a like position would exercise under similar circumstances. This duty of care is set out explicitly in the not-for-profit corporation law in section 717A, and it's basically the oversight function that the board has. And as you might imagine, you can't perform adequate oversight if you don't have familiarity with the organization's finances and activities, and if you don't regularly participate in its governance. In the supplementary materials that I provided for today is a summons in the Healing Arts Initiative lawsuit a few years ago, and that was in New York Supreme Court. And what you'll see right off the bat there, and I like to use this because it's so short and sweet, but it gets right to the point. And right at the front, you see that the defendants are the 7 or so people who are on the board of directors. They're named individually. And the summons says that it's an action to hold accountable the directors of Healing Arts who, in violation of section 717 and 720 and other parts of the statute and common law, neglected, failed to perform, and violated their duties, including their duty to act in good faith with the care of an ordinarily prudent person in a like position under similar circumstances in the management of the organization. And that language in bold should look familiar because that was the statutory language that provides for the duty of care. We'll move to the duty of loyalty, which is the director must act in the interest of the organization. It requires an undivided allegiance to the organization's mission when using the power of the director's position or information concerning the organization or its property. And where we see this duty of loyalty come into play continually is in the area of conflicts of interest and related party transactions. Hopefully we'll have time, depending on how quickly I can talk, to get to some of that later, but probably everyone on the call knows that conflicts of interest and related party transactions are very important to the Internal Revenue Service and incredibly important in New York State nonprofit law. It was a big part of the changes to the law that came online as part of the Nonprofit Revitalization Act in 2014 and is a huge priority for the Attorney General. It's a huge priority for the state legislature. It is used continually by adversaries, both internal and external, and we use it all the time when we have litigation against nonprofit boards that we're bringing, and we see it used all the time against nonprofit boards. Duty of obedience, which is the least, this is the third fiduciary duty, the least understood and most often neglected of the 3 primary legal duties. You don't want to neglect any of them. What is the duty of obedience? To ensure that the organization complies with applicable laws and regulations and its internal governance documents and policies. Compliance with applicable laws and regulations is more difficult than it sounds because there are multiple layers of laws and regulations. So of course you've got the not-for-profit corporation law. We're going to focus a little bit on that today, but there are many, many, many other laws and regulations. There are additional layers, both state law, federal law, and local law. One example is that in terms of lobbying, there are regulations on the Internal Revenue Code. There is federal, state lobbying law, and there are local lobbying laws, and they all deal with lobbying in a slightly different way. So the duty of obedience with respect to compliance with law is a handful. In terms of the not-for-profit corporation law, a huge misstep is what I have in red here. Best efforts under the circumstances is not the compliance standard. When new clients come into us, when they've got a problem that they're looking for help to address, what I so often hear is some of the complications and how they did the best that they could under the circumstances and who could expect more. The reality is that that's not the standard. The law is the standard. There are mandatory requirements and procedures, bright lines. It's rigid, inflexible, unforgiving. Example that I find probably most extreme, and I give it in this context, is that during the height of the pandemic, one of my cemetery clients, and most cemeteries in New York are nonprofits, and one of my cemetery clients, which ran crematories, and as you can imagine, in the height of the pandemic, they were, in terms of their burials and the cremations, they were overwhelmed. And under tremendous stress, they wanted to postpone their annual meeting, and they couldn't get a waiver to do that, even under those circumstances. So the law is incredibly inflexible and rigid, and there's no alternative but to recognize that and comply. Another part of the duty of obedience is compliance with internal governance documents and policies. Chief among them, the certificate of incorporation, and key there are the corporate purposes are in the certificate of incorporation. And that is one of those inflexible obstacles in nonprofit law. You must comply with your corporate purposes and you cannot operate outside of them. There are ways to amend your certificate of incorporation, but if you don't amend, then you're stuck with those purposes. And no matter how worthy the cause that you want to diverge from those purposes, it's not permissible. Compliance with bylaws, having bylaws that actually follow the law is critical. Corporate policies, committee charters, all of that is part of the duty of obedience. So let's hit some common missteps quickly. And again, I apologize for the speed. Conflicts of interest in related party transactions. It's required under the statute that before joining the board, so it's a little counterintuitive, even before joining the board, before someone is elected or appointed to the board, they need to complete and submit to the organization a conflict of interest disclosure questionnaire. In addition, the statute requires at least annually that everyone on the board, every officer, every covered person, which is a defined term under the statute, completes, and actually it's key person, sorry, not covered person, key person. That requirement is that at least annually each of those three categories of individuals submit a disclosure form, but that's not enough. Conflict disclosure is ongoing. So if there is a potential conflict and you submitted your annual disclosure a month ago, you've got to submit another disclosure form immediately. So it's before joining the board, annually, and whenever a conflict arises. Understand that the conflict of interest rules are mandatory. They're extensive. Our standard conflict of interest policy is 9 pages without the disclosure forms. Those procedures are required under the statute. You can't diverge from them, and the statute is so specific that it literally, in one instance, requires magic words. If the board wants to approve a related party transaction, which is a financial transaction between a director, officer, or a key person and the organization, it's not enough to approve it unanimously. The board needs to adopt a resolution that says that the board finds that the transaction is fair and reasonable in the best interests of the organization at the date that the board is acting. So those are literally magic words. Investment policy, also required under New York law. NFP, New York Prudent Management of Institutional Funds Act, is embedded in Article 5 of the Not-for-Profit Corporation Law. There too, there are mandatory provisions, mandatory procedures, including any time that an investment is made, the board or the investment committee needs to consider certain statutory factors, and you need to reflect that in the minutes. Similarly, with conflicts of interest policies and compliance there, the minutes are key because 2 years from now, the minutes are all you've got to be able to show that you complied with these very rigorous requirements. File cabinet syndrome. Just looking at how we're doing on time. File cabinet syndrome. So what we sometimes see when clients come into us, and sometimes you see this in enforcement cases, for instance, in the litigation that the Attorney General brought against the National Rifle Association, the Attorney General in its complaint pointed out that in certain instances, the NRA had quite wonderful and compliant policies, but they didn't look at them. They didn't know about them. They didn't follow them. So file cabinet syndrome is when you have compliant policies and you file them away and you don't follow them. And that's something you really want to keep your eye on and avoid. The IRS Form 990, it's something that's filed with the IRS, of course, but also with New York State and other states that you may operate in. And that document is designed for maximal transparency. The IRS even asks you questions about things that the IRS can't regulate. And they say that in one part of governance section. We're about to ask you questions about policies that the IRS doesn't require. But nonetheless, we're asking you about them because we want to put it out there for everybody's information to gauge what your governance practices are. So the financial information, the governance information, the 990 is signed under penalties of perjury. We very often see, this is such a common misstep. We very often see 990s that aren't carefully reviewed by the board and the officers, and that can cause a huge problem. And one of the questions in the governance section of the 990, in fact, is what is the process for board review of this 990? And we sometimes see that wrong. Sometimes I've seen clients come into us and I look at their 990 and I see all sorts of right on the face that without even knowing much about them, I could tell that that these answers are all wrong. And I asked them about it, and they say, well, we never looked at that. We just had our accountant do it, and we signed it, and it got filed. And then I look at the question about what was the board process for reviewing the 990, and it says in the 990 that the board received the 990, reviewed it, and approved it before it was filed. So not what you want to do. The 990 is something that should be very carefully reviewed by everyone on the board, including all the officers, before it's signed off on and filed. Bylaws trap. Bylaws are very easy to amend. All you need is a board meeting in most instances to amend, not all, but in most instances, it's enough for the board to meet and amend the bylaws. And lots of times I see provisions in bylaws that are very rational and logical, except they are inconsistent with mandatory provisions of the law. So don't fall into that trap. Make sure that you've got a lawyer experience in nonprofit matters and intimately familiar with the not-for-profit corporation law that vets any of your bylaws changes. Also, a very common trap and misstep is what you can tell from everything that I've said at hyper speed here so far, that there are lots of legal duties imposed on nonprofit directors and officers under the law already. So the last thing we want to do is inadvertently create more duties. And remember that the duty of obedience requires you to follow your bylaws. So follow me for a second here. If we put in our bylaws that we're going to have a board meeting every month, that now is a fiduciary duty of every officer and every director to make sure that happens. If it doesn't happen, we've breached our fiduciary duties. So let's not put a provision in our bylaws that requires a board meeting every month. If you want to meet once a month, great. If you want to meet twice a month, great. But don't make it a fiduciary duty that could lead to a breach of fiduciary duty claim against board members and officers, because you've already got enough fiduciary duties to deal with. We talked about conflict of interest policies. Under the law, the conflict of interest policy has to apply to directors, officers, and key persons. It's very rigorous, the most demanding of any state in the country. So be very careful not to add other people into this conflict of interest policy. Don't say that it applies to every employee. If you want every employee covered by a conflict of interest policy, have them covered by a different conflict of interest policy that isn't as demanding as the conflict of interest policy that's required under the statute for directors, officers, and key persons. Again, the theme is you've got enough fiduciary duties, don't add more. Annual meeting, that's what it says. It's an annual meeting. You got to have it at least once a year. Two things have to happen. Elect directors, provide an annual financial report. What's in the annual financial report is required under the statute. So that's something that you should work on with your lawyer to make sure that you're providing the necessary information and doing it in a timely fashion. There's a timeliness requirement in the law that's very easy to have a misstep in connection with. So this is something to be very careful about. And again, is something that leads to lots of claims against directors and officers. Audit oversight is a key aspect of the 2014 revisions to the not-for-profit corporation law. The only committee that has a separate section of the statute dedicated to it is the audit committee. And there are very detailed mandatory provisions in 712A. If you are required under the executive law to file an audit with the Attorney General every year, then either your audit committee, which can only be comprised of independent directors, or the board as a whole, but only the independent directors on the board, have to fulfill those audit oversight requirements. Email voting, another very common mistake that nonprofits make. You can't vote by email in New York. It's not permissible. There are two ways for the board to act: at a meeting, which can be in person by conference call or by video conference, or by unanimous consent in lieu of a meeting. And that unanimous consent can be by email or other electronic means, or it can be written. But it's got to be unanimous, and that means that it is not voting. So you can have 50 members of a board. If 49 of them provide an email consent and one of them doesn't, and I had this fact pattern, even if that person doesn't vote no, if that person just doesn't respond, it's not a unanimous consent, and the board can't act that way. And the effect of mistakes in this area are that you've got the board believing that they've authorized something that hasn't been authorized, and that can be a disaster down the road. Committees are a very sensitive area. They're tremendously technical provisions. So with respect to committees, which are essential for any nonprofit, you need to coordinate that with your lawyer and make sure that the very detailed provisions of the law are being followed. The NPCL, the not-for-profit corporation law itself, is chock full of traps, in the sense that they invite missteps because they're very technical requirements. So quorum has all sorts of technical requirements that you can't go below. And there are all sorts of other very specific provisions. So I think we've reached our time limit. I apologize. I had a lot more to be continued at another time. Hopefully you'll have time to look through the rest of the PowerPoint, because there's lots of information in there, as well as in the supplementary materials. And you can call me if you've got follow-up questions. And I promise that I'll talk a lot slower when we're speaking one-to-one. Thanks very much, everybody. And call Doug or I if you've got any follow-up. Looking forward to speaking to you in person at some point. So long.